Good day, colleagues. My name is Possible, and I'll be your tutor for today. Don't forget that in lesson 9, we introduce what is called family property. And then, with respect to that, we understood that Ningo Pram Pram, Shai, and Ga Adangbe lands are into the hands of the family, but not the stool. Again, we also introduced Article 36, Clause 8 of the 1992 Constitution of the Republic of Ghana. From there, we talk about family land based on Section 281, the interpretation aspect of the Land Act. From there, we also talk about stool land based on Section 281. Again, we introduce what is called family property. And then we look at the types of family under customary law in Ghana. Now, we also introduce our objectives, things that we are going to pay attention to. We said that by the end of the lesson, we should be able to explain or discuss what acquisition means. And then we should be able to explain what alienation also means. At the end of the lesson, we should be able to explain acquisition, what acquisition of family property means, alienation, litigation, accountability, and then explain election of family leaders, and then deposition or removal of them. This is going to be an extensive class. Pay attention. Grab a sheet of paper and pay attention as we dive into it. But before then, let us pay respect to the Land Act. So we are spending about 10 to 15 seconds to pay respect to the Land Act because it has done as much good than harm. Let us pay respect. All right. Now let us zoom into what we have under discussion. We are looking at family property. But family property, to better understand it, it has been categorized into 6 sections: acquisition, alienation, litigation, election, deposition. In fact, it has been categorized into 6 sections. We are going to shift our attention on these and learn them one after the other. By the end of the discussion, you should be able to know your rights and then the laws and the legalities and the principles so far as family lands or family properties are concerned. So quickly, we are beginning with what is called acquisition of a family property. Now, don't forget that I've introduced to you what a family land means or a family property. I've also introduced to you what a stool land or a stool property also means. Now, before then, what I want you to understand is the modes of acquisition of family land. When we are talking about family lands, we have ways that these lands could be acquired. Modes of acquisition of family land. Ways at which family lands could be acquired. A is acquisition with family resources. This happens whereby we are acquiring the family property with the resource of the same family. Number 2 is by succession. Number 3 is by building by a member on family land. When a member of the family builds on the family land, then it becomes a family property. Number 4 is redemption of family property by a member. Redemption of a family property by a member. Then number 5 is gift. And number 6 is severance family ties. In fact, at the moment you are able to explain all these, then you are good to go. Make sure to understand this one after the other. So we are going to discuss them. All these are under acquisition of a family land. Acquisition of a family land. So far as land law is concerned. Acquisition of a family land. Now, understand very well that when we talk about acquisition with family resources, there is a basic rule that is governing that. The basic rule is that all property acquired with family resources is family property. Yes, indeed. If you acquire the property with family money, then it belongs to the family. If we have a bank account and the head of the family goes into the bank account and use the bank account to buy a land, then it belongs to us. If we go into the coffers of the family and then we use the money and money from there to buy a building, then automatically it becomes a family property. So you should understand. Here, we need not to leave this one in the hands of the judges to even tell us this. So understand this. It's a general principle or a basic rule. Property bought with family money, automatically, the clearest instances of this are where income from existing family property or the proceeds of the sale of family property are used to buy more property. So probably you have a village building and then you go and sell it. The family has a village building, almost 4 village buildings of a village land, and then the family goes ahead to go and sell those property and use it to acquire another property in the city. It becomes the property of the family. So this one is undisputed fact. Ineguable. It's not supposed to undergo litigation. When you acquire further properties from the coffers of the family, or that property that you have bought, the new one, must belong to the family because you took the money from the family's coffers. So it is an undisputed fact that you must understand. So you must understand that when you pick money from the family's coffers and then use it to get additional property, it belongs to the family. So income from family property, that is what I've said, it is frequently allotted to members of the family to help them in their education and other enterprises. After such allotment, the money is the individual property of the member to whom it was given. If these are principles, you should understand all these principles. If there is a family coffers, and out of this family coffers or family pairs, you pick money. In fact, you must understand this because a particular case, a particular case is about like a particular case felt before the court for the court to determine, and then they use this principle. That's the case of Labi versus Kato. This case, okay, we will talk about that. So you should understand that when you pick money from the family coffers and you distribute it to the members of the family, the allotted portions to the members become their own property because you distributed the money to them. So assuming I use my own to go to school, later on you can't come and tell me that, oh, you finance my school with the family property or the family money. So whatsoever I do belongs to the family. No. Understand this principle. So when you give money, you take money out of the family purse, use it to sponsor people for them to go to school, or you distribute to them, it becomes their own property. Understand it. Now, property acquired by construction with materials belonging to the family. If you are constructing a building, with materials that belong to the family, what will happen? So does a house built with a small quantity of materials from a family house belong to the family or become a family property? If you build, a family has a land, a family has a land, and then possibly you have traveled outside, probably to America or to Europe, and then you have come back to your country and you are saying that, well, when I was living, the family was having a land. So there is no need for me to go and buy additional land. Let me go and build my house on the family land. Now the question is, in law, does that house that you have built belong to the family? That's the question. Now, when you read the case of Kujo versus Kwache, and then the case of Amisa Abadu versus Abadu, in fact, we will read all these cases before we end the class. You understand it very well. But before then, let me give you a gist. The principle is that if only the resources you took from the family is not substantial or is not rare, then the property that you have constructed cannot become the property of the family. Under the question that I've asked, building your house on the family land, you could see that the land belongs to family. Land is substantial. So automatically the building that you have built becomes a family property. And then the family, it will serve as a mean of which the family will acquire a land. Please understand. So the principle is that the situation whereby the resources or the material that belong to the family are immaterial, then the property that you have built or you have constructed will not become a family property. I think this principle is laudable. It is laudable. If you use family materials, if you use substantial portion of family materials, then it must go to family. If you use insignificant, like someone cooking for you, someone was cooking for you whilst you were building your house, or someone was cooking for you whilst you were doing your cocoa farm, that person cannot just say it belongs to a family because I was the one who was cooking for you when you were preparing your cocoa land. No, that person cannot do that. Or when you were working on your cocoa land or cashew. So that person cannot argue and that person cannot dispute. So understand this principle from here. Now, let me also ask this one. Property that are acquired by joint labor of the members of the property. So properties also could be acquired by the property. Could be acquired by the family. Whereby the family jointly use their labor, substantial portion of their labor, in order to bring that property into its current state. So such labor may be expended for the cultivation of a farm, which may be the act whereby a usufructuary title is acquired, or for the construction of a house. The farm or house belong to the family. So if the entire family come jointly and use their labor, they contribute their labor, their effort, all of them, from head to toe, from a bushia penny to the children who are in primary, and all of them will be carrying marbles, gravel, sand, everything, and then they use it to build a house. One person who contributed cannot just rise up and say, yes, after all, the rest of you were carrying the marbles and then the sand. I was the one who was laying the blocks. So I'm the one who can stand up and claim the ownership of the land or the ownership of the building. The law says that person cannot stand to claim the ownership of the building. So understand it. Property acquired by the joint labor of the members of the family belongs to the family. Understand? In the case of Nkonuya versus Anafi, you will see this one. And also in the case of Amisa Abadu versus Abadu, you will see this case over there. So this situation should be distinguished from that, this case should be distinguished from the situation whereby an individual who owns self-acquired property allows members of the family to make use of it. I have built my house. I have built my house. And then I have allowed the family members to come and stay in it. And they have stayed in it. And then possibly there was a heavy downpour or rain. And then the roof has been destroyed or has been demolished. And then the family members have contributed money to roof it again. The family members cannot just say that the building belongs to them just because they are the ones who roof it. No. So if it is a self-acquired property of the individual, then it belongs to the individual. In fact, law is laudable. It makes sense. So understand it and understand the principles that are governing all this fact. Let me add up to it. Property that is acquired by the joint labor of the members of the property. You can also read from Labi versus Kato. But Mensah versus Square, where an individual who owns self-acquired property allows members of his family to make use of it. That one we have realized that automatically the family cannot claim ownership over that one. Again, Kojo versus Kwache, where we are looking at, we said that did the building of the small shed by a family member on the property of Kwache make his property family land? No, it is not a family land. Understand it. It is not a family land. If I have a building and then I'm letting my family members to come and then stay in there, they can't just claim and say that it is family land. No, it belongs to me. So let us look at building by a family member on a family land. When a family member is building on a family land, a family member is building on a family land, what will be the results? There is a family land somewhere. Probably it is in your village. I think I've already said it. There's a family land in your village, and then you have gone there because probably you have returned from America or you have returned from Europe, and then you want to come and build on the family land. Please understand it. When you are done building on it, you cannot give it to your children. You cannot give it to your children. It doesn't belong to you. It belongs to the family. So building by a family member on family land, the erection of a building by a member of a family on the family land may fall into either of two categories. It will fall into two categories. Two categories. Number one, the building may constitute the exercise by a member of his inherent right to make use of vacant ancestral land. Don't forget usufructuary interest under Section 5 of the Land Act. Section 5 of the Land Act. What we learned under usufructuary interest. We said that under usufructuary interest, the individual has an inherent right to reduce an unoccupied or inappropriated portion of the land into his lawful possession. Law is interesting. Law is interesting. To reduce it into his lawful possession. Under such regard, if the land is vacant, unappropriated, and then unoccupied, and then the person or the member of the family has been able to reduce it into a useful portion and then built on it, then automatically it becomes the person's land. So in such a case, his occupation vests in him a usufructuary title maintainable against the whole world. Under such regard, the property belongs to him. So there is a family land somewhere which is in the bush, in the forest. No one even goes there to visit it. And then even if someone goes there to visit it, it is a forest somewhere. And you have been able to reduce it into a place that is well enough to stay, that one, the property that you built on it will belong to you. B, if the erection is not on vacant family land, it will be carried out under the terms of a building license granted to that member by the family. So that one also, the family will look at it from two perspectives. Was it the family who gave you the permission to go to build it on it by the concurrent and the consent of the principal members, or in fact the family? Was it a family that gave you the permission to build on it? If the answer is no, then you have done that as a gift for the family. So understand this principle once and for all. And for all. So if it is not the family that gave you that permission to do it, then it means you have done it for the family. Now, building by a member on family land. The issue here is, what is the effect of a license to a family member on the ownership of the land and of the building erected on the family land? This may, of course, be governed by express terms of the license granted by the family. So, upon the concurrent consent of the members of the family that you can build on the land, if they give you a building license, then the next question is, that building license they have given you, what are the express terms of that building license? Does it say that the land will at the end of the day come back to you, or what? So the express terms of that building license is what is going to be used. If not, it shall automatically go to the family. It shall automatically go to the family. So the case of Santin versus Dakwa, 1940, West Africa Court of Appeal, 1940. One of the houses in dispute had been erected by a family member on the ruins of an old family house. The case was governed by the customary law of Achim Abuakwa. The court held that the site remained family land, but there was no authority for holding that the house became family property. So that is how it is. Now, let us continue with the building on the family land. The building on the family land. The case of Owu versus Owu, 1945. 1945, West Africa Court of Appeal. 1945. This case was governed by the GA, Greater Accra Customary Law, GA. The court held that, according to native custom, land upon which a member of a family obtains a license to build remains family property. The testator, the person who did it, the testator, that is the member who had built the house, would have a life interest in the house he built upon the land. Upon the testator's death, however, the house becomes family property after the death. Emphasis added. This was also reaffirmed in the case of Ansa versus Saki, 1958, West Africa Law Report, page 325. The case was reaffirmed in that. So it means that when someone builds on a family land with the permission of building licenses, we are saying that the property, whilst the testator is alive, the property will automatically be the testator's own. But at the death of the testator, the property now reverses to the family. It becomes family property. Understand this principle once and for all. Now, moving forward, we are still on the building by a member on family land. The scope of application of the rule must now be examined more closely. The situation must be distinguished from that where the member acquires a usufructuary interest in both land and house, which he may dispose of beyond his lifetime. So the first one that I said, if there is inappropriated land, if there is unoccupied land, and then the member of the family has been able to reduce it into his lawful possession, automatically it becomes the property of the member of the family. And no one can rise up and dispute that fact. Because of Section 5 of the Land Act 2020 at 1036, the usufructuary interest that a person is holding in the land. Understand the principle. Let us look at what the learned judge Olenu J, Justice Olenu J states that the rule applies when a house is built on family land as distinct from waste ancestral land. So it is not waste ancestral land that is somewhere. He later amplifies this by stating that a determinable or usufructuary title is acquired by the member if the land is general family land, that is a site which has not previously been granted to another individual member of the family, or a site which another individual member has not previously effectively occupied. And he contrasts this with family land in use by the family. Understand it. Olenu J has made it so clear. It means that if the land is inappropriated and unoccupied, vacant, and the member of the family is able to reduce it into his lawful possession, then the person has triggered Section 5, which is the usufructuary interest. The person has triggered Section 5 of the Land Act, which is the usufructuary interest. Usufructuary interest says that usufructuary interest is an interest in land which is acquired in the exercise of an inherent right by a subject or a member of a stool or skin or family or clan, which holds a allodial tithe through the development of an unappropriated portion of the land of the stool or skin or family or clan, or by virtue of an express grant. So when you reach section 5, of the Land Act, then you get to understand this. Go and watch our previous lessons. I have explained what usufructuary interest mean. So understand it very well. Now going forward, we are still on the building by a member on a family land. The situation must be distinguished from the building of a mere addition to an existing structure. The family has a structure there. The family has a building there. And then you go there and you go and paint it. You want to claim it. No, you can't claim it. The building is there and you just went to paint it. Or the building is there, but it has not been roofed and you went there to roof it. The building is there. There is no door. You went there to put door on it. And you want to claim it as your property. No. So, it would not be reasonable for the presumption in favor of an alienable life estate to arise when, for example, a member adds a room. A member adds a room to a family house. Since here, there will be prima facie a clear intention to benefit the family. Yes. A family property is there. Family building is there. And then you just go and then complete one room and then you come and stay in it. When you are dying, then you make a will. You want to give it to your children. No, it is not yours. It is a family property. It is a family property that we must respect it. It is a family property that we must respect it. It is a family property. So that is how it is. Indeed, since such an addition makes use of the existing building and cannot be used separately, it could be considered an acquisition in which family resources have been used. Don't forget that we are still on the one aspect of acquisition. That is acquisition by the family at the scenario or at the point where the family resources is being used. When you use family resources, you can't claim the property to be yours. The property belongs to the family. So we are saying that the family has acquired that land. You have built it for the family. So the family has acquired that land. Don't forget. Or the family has acquired that property. Now, we are moving outside that to redemption of family property by a member. Redemption of a family property by a member. Redemption of a family property by a member. Redemption of a family property by a member. Now, when we talk about redemption of a family property, we are talking about the situation whereby possibly because of a debt. You see, ideally, customarily, when there is a family debt, one of the obligations of the family members is to pay the debt jointly, the family debt jointly. So, the situation whereby possibly there is a family debt, and then the person, the creditor, yes, the person to whom the family owes, is coming to take the family property. It's come to claim it and use it to settle the debt. And then one person rises up and says, yes, I want to redeem that property. I want to redeem our family property. What are the principles that govern it? What are the principles that govern it? We are saying that a family could also acquire property from that. A family could also acquire property from that. So far, don't forget that we have analyzed the situation whereby a family is acquiring land. We are still within acquisition. The situation whereby a family is acquiring land. But by this acquisition, the family is acquiring it as a result of its members using its resources. Number one, of which we have analyzed it from different perspectives, different principles under that. Number two, we are looking at redemption of family property by a member. So, redemption of family property by a member. This concerns the reacquisition for the family of property to which it formerly had title. So you are reacquiring the property. The title may have been lost in either of two ways. Number one, the property may have been pledged according to customary law or mortgaged according to common law. Number two, the property may have been lost in some way with an appearance of greater finality, such as sale or foreclosure under a mortgage. So, probably you pledged, the family pledged. The family went for a loan, went for something. And then because of that, the property is now going away. Under common law, the situation whereby we use mortgage, the property for mortgage, and now the family cannot settle its obligation. And then the family has defaulted its payment. And then because of that, they are claiming the property. And then the person rises up and says, yes, I will make sure to stand in it and then do it. And then redeem the property. What are the principles around this? In either case, If a member of the family recovers it, it may resume its character of a family property. Don't forget, in the case of Manukure and another versus Eniapam and others, 1976, 2 Ghana Law Report, page 339 to 342. Whatsoever the case might be, it will still come back to the family. However, it is rebuttable presumption. It is rebuttable presumption. The situation whereby you expressly and explicitly made it aware to the family that you want to acquire it, but after the acquisition, it will become your property. And then the family consented. Then you go ahead and pay the loan and pay the debt that the family is owing. And after the payment of that debt, then it becomes your property. Don't ever think that, oh, after all, the family is owing. So if the family is owing, and then the property is going out to become the property of someone, and then I stand in and pay the loan, then it's supposed to be mine. Or if the family wants the property back, the family have to pay me the money I used to settle the loan. You lie bad. You lie bad. You lie bad. So if you want to pay the loan and the property becomes yours, meaning that you are buying the property, then make it very clear to the family, explicit and express. Do that. Let them get to know, understand in the presence of witnesses that you want to pay the debt of the family and reclaim the property of the family to be your personal or to be your private property. Under such circumstance, the family gives you go ahead, then it automatically becomes your property. The next one is severance of family ties. Severance of family ties. That one also is another form of acquiring land. That one also is another form of acquiring land, so far as the land law in Ghana is concerned. It's another form of acquiring land. Acquiring land. Severance of family ties. Severance of family ties. Now, customary law provides that a single family can divide into 2 or more independent families. When this happens, lands which belong to the original family will be divided between its successors. The principle is so clear. A family is there. It is one family. Now the family has been divided, probably due to 1 or 2 things. The property belongs to the original one family. Now, if it has been divided into family A and family B, then let us divide the property also into family A and family B. Divide the property into A and B and share among these families, new families that has emerged from the old one. I think the principle is so clear. So, in the case of Okaiko versus Opare and Mensah, 1956, 1 West Africa Law Report, page 275, will make it so clear. Okaiko, Okaikor, Okaiko versus Opare and Mensah. Opare and Mensah. Opare and Mensah. 1956, 1 West Africa Law Report, page 275. Now, so far, what have we discussed? Let us look at some of the takeaways. What have we discussed so far? What have we discussed? The principles, takeaways. Pay attention. Pay attention here. How privately acquired property could become family property. So far, that is what you have discussed. How family could acquire property. So we are looking at how privately acquired. Individual members have acquired property, but now it is becoming the property of the family. That is what we are looking at. Substantial contribution by the family. So far, what you have discussed, we are compressing them. Number 1, substantial contribution by the family. For a self-acquired land of a family member to become a family property, the family's contribution in respect of the development of the property ought to be substantial, such as A, where the land is acquired by a family member but was substantially or wholly financed by the members of the family. So a property, a self-acquired land of a family member can become a family property, whereby the land is acquired by the family, either substantially or wholly. So it means that if there is a family contribution in it, but it is insignificant, then automatically it can become the property of the family. But if it is wholly or substantially contributed by the family, then automatically the property becomes a family property. B, where land acquired by a member of the family is improved or developed with structure which is substantially built or wholly built with income from the family's property. If you pick income from the family's property and use it to build your house, if you pick money wholly or substantially, it becomes family property. C, where the land is acquired by a family member, but a substantial part of labor or the whole labor is used on the building or in the cultivation of cash crops was provided by the family. In the case of Labi versus Kato, the family, they come together to use their joint effort or labor to develop your land or to build it or to do something on it for you. Then it becomes family property. Don't forget. We also look at operation of law. Operation of law. Operation of law. When a member of family dies intestate, the person died without a will. When a member of family dies intestate, his self-acquired properties will devolve by operation of law to the immediate family. Please, the underline one is immediate family, and not the wider, which is the extended family. The immediate family here is also distinct from the nuclear family. So understand it. When we talk about the Fante custom, if we are talking about the Fante custom, it refers to the mother of the deceased and her descendants. So if someone dies intestate, according to the Fante custom, the property of the person falls to the immediate family, and that immediate family under the Fante custom is the mother of the deceased person and the descendants. If you want to understand it, see the case of Andrews versus Hayford. Andrews versus Hayford. Again, failure of successes. Failure of successes. Where the member dies without a surviving spouse, parent, or child, then his whole property will devolve under customary law, which invariably goes to the immediate extended family. Section 11(1) of the Interstate Succession Law, Interstate Succession Law Act 1985, PNDC Law 111, Provisional National Defense Council Law 111. It reads, where the intestate is not survived by a spouse, a child, or a parent, the estate shall devolve in accordance with customary law. The next one, at which the family will acquire the land, the summary, takeaways. That is gift to the family. A member of the family may either during his lifetime or in his will gift out his movable or immovable property to his own family. Therefore, if he gives it out his privately acquired land to the family, it will become family land. So it is self-explanatory. If the person explicitly gift out his own property to the family, then it becomes family property. Then repurchase or redemption of family property. Where family property is lost through sale or other attachment, and a member repurchases or redeems the property with his own funds, it becomes family property unless, I've explained it already. I'm giving you the takeaways. Unless members of the family were specifically informed at the time of the repurchase or redemption that the property will not resume its former position as family property. So unless the person who is redeeming it makes it so clear to the family that after I have redeemed it, it will become my own property, my private property, and then the family consent, then that one automatically in the presence of witnesses. So see the case of Engonama versus Asiet and Bruce versus Ejaha. All these cases will let you understand it very careful. What about the general principle on property rights of a member of family? The general principles on property rights of a member of family. The general rule is that property acquired with family resources, such as income from existing family property, or where family property sold and proceeds is used to acquire other property, such property is family property. I think this one is also very clear and laudable. So where a member acquires property with a small contribution from the family, the property does not assume the character of a family property. Remember what I said. If the contribution from the family is insignificant, then the family cannot by any means claim the property to be theirs. The property shall definitely fall into the hands of the private person. So you shouldn't forget this. Now, in Amisa Beidu versus Abeidu, the deceased, out of his own effort, built the disputed house on his family land, which he occupied with the defendant, his surviving wife, and their children. His mother supervised the construction of the house, and his sister rendered him other services such as cooking. They were married under ordinance. He made a will where he divided the said property to the defendants and the children. On his death, the plaintiff, his customary successor, brought an action on behalf of the family for a declaration of title to the house on contention that the property was that of the family. The court held that the nature of the contribution offered by the deceased mother and sister did not constitute a substantial contribution as to even taint the house with family character. The mother cooked, the sister cooked, or probably they washed his clothes when he was building his house. They want to say that it's a family property. So you can also see the case of Kujo versus Kwache. So I just finished reading the case of Amisa Beidu versus Abeidu. So that is how it is. Again, the fact that a family member benefited from financial support of the family towards their education does not make property subsequent acquired by them in the future become family property. You use family money, family fund, to pay my school fees for me to complete school. And now I have built my house. And you want to say that it is family property just because when I was going to school, you contributed to my education. That is not true. So in the case of Labi versus Katu, I told you we'll be reading it. I told you. A.O. Labi died on 30th September 1956. In 1937, he had built house number C226/1 on Insawamu Road, Accra, on self-acquired land. He added to the building in 1950 by deed of gift dated 24th March 1952. He conveyed the property to his son, A.O. Katulabi, and confirmed the deed in his will dated 19th September 1952. At his death, the ownership of the property was therefore vested in A.O. Labi, his own son. So he used his own son, and then it was vested in him. In 1957, the brother of the deceased brought an action in which he claimed inter alia, a declaration that the said property was family property, and therefore property of which the deceased was not entitled to dispose. The basis of the plaintiff's claim was that the deceased had built the premise with the financial assistance of various members of the family. The action was dismissed by Olenu J, and the plaintiff appealed. At the hearing of the appeal, it was further argued on behalf of the plaintiff that as the deceased had been educated with the assistance of family funds, his subsequent earnings and property acquired were stamped with the mark of family property. Evidence at the trial indicated that the deceased took £30 as a loan from the family fund, but the overall cost of the building was £2,500. Just £30. And overall cost of the building is £2,500. It is not substantial. It is insignificant. Let us look at the holding of the court. The court held that those members of the family who make contribution to the building of a house are entitled to share in the enjoyment of the building. But this is and must be on the basis that by accepting support and contribution from the family, the builder recognizes that he is building a house for the family. It is quite otherwise when a person is building his own house and seeks assistance by way of loan or as his personal share of a family fund in order to complete the building. The court further held that the customary law of Ghana does not impose upon sons of the family who have received professional education with the support of family funds an obligation of repayment, nor do the earnings of such sons take upon themselves the character of profit earned by the use of family funds. So, customary law does not know the family supported you. So when you come, whatsoever you do, it belongs to the family. No. Again, when one member of the family acquires land with his own resources and other members provide the funds to build on the land and the house becomes family property. Don't forget, a member of the family acquires a private or a personal land, and then you allow the entire family to build on it. Then it becomes family property. In the case of Boafo versus Stott, where a member makes an extension to existing family farm or improves him, the essential character of the farm remains family property. So when individual also go and whiz the farm or that belongs to the family, probably the cocoa, you can't just say that it belongs to you. So now I'm going to pluck the cocoas and then chop the money. No, it belongs to the family. Understand all these principles. In Nkonia versus Anafi, evidence proved that a farmstead belonging to the royal Adriana family was developed into a cocoa farm by the chief when he was installed. The court held that the cocoa farm remained the property of the family. The court further held that where a person acquires a property with the assistance of a member of his family, that property becomes a family property. Therefore, if an occupant of a stool acquires property with assistance of a member of his family, the property is not stool property, but the family property. It's the family who supported him after all. So the stool cannot claim it. but the family property of these two occupants. In the instant case, the evidence establishes that the plaintiff assisted Nana Akese physically and financially in making the cocoa farm. The farm is therefore family, not stool property. Not stool property. The next one is where a member extends or improves existing family building. Such improvement does not change the character of the building, which remains family property. He cannot therefore alienate the building. He cannot therefore alienate the building. So where family property is lost through sale or other attachments, and a member repurchases or redeems the property, I think I've talked about this one. So Ngunama versus Asiedu. Ngunama versus Asiedu will give you the position of this. Now, where family keep a common purse, any property acquired becomes a family property and does not force to the last surviving person. Don't forget. If a family keeps a common purse and you go to the family purse and then you use something, they use the family purse to buy something. It belongs to the whole family. It doesn't belong to the individuals. In Yoguo versus Ajekum, the plaintiffs were brothers. During the lifetime of their deceased father, he cultivated cocoa jointly with his late brother on family land. Their father and his brother jointly saved the proceeds from their respective cocoa farms and then used the proceeds to build a house. The plaintiffs claimed that their father during his lifetime gifted the house to them. The court dismissed the claim of to the plaintiffs. The court held that where two family members kept a common purse, whether was acquired from the common purse, had the character of family property. The character of family property is not changed unless partition during their lifetime became full family property to their death. So it means that if jointly you use the family purse to construct something, automatically the property becomes the family. Again, let us look at this principle. Where social obligations require some individuals to assist another person, social obligation. A son helping mother, mother helping son, a son helping father, social obligations. Where social obligations require some individuals to assist another person, and such assistance is given, any property acquired is the individual property of the person so assisted. Indeed, under customary law, where a child assisted his father or guardian to acquire property, he did not become a joint owner of that property. If a child assists his father or mother, he doesn't become a joint owner. Don't forget, the principles are plenty, but they are laudable. He doesn't become a joint owner of that property. In the case of Yoguo versus Ajekum. So where the deceased lived, the next principle, which might be the last principle, is where the deceased, the dead person, the situation whereby the deceased live in a family house with his wife and children. The widow and the children had no interest, save a right of occupation subject to good behavior. So the situation whereby a husband and wife, they live in a family house. At the death of the husband, the family house doesn't belong to the children. It doesn't belong to the wife. And then the family could also decide to sack the wife from the house or the children from the house. But remember, we are saying that it is subject to a good behavior. What constitutes a good behavior under the law is a question to be determined by the law courts. It is at the whims and the caprices and the discretion of the court to determine. So the case of Emis Abedu versus Abedu is the one that will deal with this. What is the current position of this case? what we are talking about. The current position of the law when a member of the family develops family land. Family members have no interest in their family land, and a member who develops a family land would only have life interest in it and cannot alienate it in his will. If you develop family land, you have life interest in it. That's the current position. You have life interest. As long as you live, you have life interest in it. And when you die or you are dying, you cannot use it as a will. You cannot do well on it. In order to give it to your children, you can't also sell it out. No, you have life interest in it. This was the position of Olenu J, Justice Olenu, in the cases of Ansah versus Saki and Santin versus Dakwa. Santin versus Dakwa. The Supreme Court has adopted this principle in Ray Yali, the deceased. So Yali versus Kells. This has been the position of the court. In our next lesson, we are going to look at family property with respect to alienation. 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 Do not forget that all this while we have analyzed how the family property could be acquired. Our next lesson, we are going to look at how family property could be alienated. Stay tuned. Once again, my name is Possible, and I've been your tutor up to now. Until we meet again another time, I will say bye-bye. Take care of yourself. Bye.